for. Now, the court actually covers our issue of interest, this reinterpretation of the statute, after it talks about the booby trap issue. So what I'm going to do is go past the booby trap issue, and we'll come back to it after we get to the heart of the matter. So People versus Bios, and by the way, if you've never looked at a court decision, an appellate court decision, this is typically how they're structured. You have the parties, the people, of course, being the state. There are most states, it would be state versus defendant, whatever the defendant's name is. I think there's 4 states that do people: New York, Colorado, Illinois, and California. Instead of using state versus defendant, it's people versus defendant, if I'm recalling that correctly. People versus Bios. Then you have the case citation, which you can think of as kind of the license plate, the unique identifier for this decision. The state, the court within the state, the Supreme Court, and the year. Of course, they list the parties: Don Luis Ceballos, the counsel for the parties. Lots of counsel here, both for the defense and for the state, especially for the state, because it's a state Supreme Court case, so it's a big deal. So lots of people get involved. The judges, unanimous view of the court. So 1, 2, 3, 4, 5, 6, 7 judges here on this California Supreme Court decision, unanimous decision. The opinion. So Don Ceballos, spoiler, they like to give spoilers at the beginning often, was found guilty by a jury at trial of assault with a deadly weapon. The sentence was suspended. He was placed on probation. He appeals from the judgment, contending that his conduct was not unlawful because the alleged victim was attempting to commit burglary when hit by a trap gun mounted in the garage of the defendant's dwelling, and that the court committed error in instructing the jury. We've concluded that the former argument lacks merit, and that the court did not commit prejudicial error in instructing the jury, and that the judgment should be affirmed. So, some facts of the case. Defendant lived in a home in San Anselmo. The regular living quarters were above the garage, but defendant sometimes slept in the garage and had about $2,500 worth of property there. In March 1970, some tools were stolen from his house. In May 1970, he noticed the lock in his garage doors was bent and pry marks were in one of the doors. The next day, he mounted a loaded .22 caliber pistol in the garage. The pistol was aimed at the center of the garage doors and was connected by a wire to one of the doors so that the pistol would discharge if the door was open several inches. The damage to the defendant's lock had been done by a 16-year-old boy named Stephen and a 15-year-old boy named Robert on the afternoon of May 15th, 3 days after this trap was set up. The boys returned 3 days after the last effort to break in. The boys returned to his home while he was away. Neither was armed with a gun or a knife. After looking in the windows and seeing no one, Stephen succeeded in removing the lock on the garage door with a crowbar. Deadly weapon, a crowbar? Depends on the manner of use, right? Sure can be. And as he pulled the door outward, he was hit in the face with a bullet from the pistol. Pretty lucky shot for a fixed pistol pointed at the width of a garage door. Stephen, the burglar who was shot in the face, testified. He intended to go into the garage for some musical equipment because he had a debt to pay to a friend. His way of paying would be to take the defendant's property and sell it, and use the proceeds to pay the debt. Oh, he wasn't going to steal for sure, necessarily. He was just there to look around. And getting in, I don't know if I would have actually stolen. That sound credible to anybody? The defendant, testifying in his own behalf, admitted having set up the trap gun. He stated that after noticing the pry marks on the garage door, on May 12th, he felt he should set up some kind of a trap, something to keep the burglar out of my home. When asked why he was trying to keep the burglar out, what kind of question is that? He replied, because somebody was trying to steal my property and I don't want to come home some night and have the thief in there. Usually a thief is pretty desperate and they just pick up a weapon if they don't have one and do the best they can. When asked by the police shortly after the shooting why he assembled the trap gun, the defendant stated that he didn't have much and he wanted to protect what he did have. So explicitly using the gun in defense of property. The jury found the defendant guilty of assault with a deadly weapon. an assault is an unlawful attempt coupled with the present ability to commit a violent injury on the person of another. So in most states, we would call what happened here a battery. There are a couple of states that use the term assault more broadly than the traditional meaning. New York's another one. But normally, a battery is when you cause an injury to someone in a way that's arguably a crime. There's contact, unwanted contact or injury. An assault is usually not that. An assault is when you put someone in fear of an imminent unlawful harm. So you put them in fear of an imminent battery. So you run up to someone with your fist raised as if you're going to punch them, and they see you coming and they're frightened of being struck. That's an assault. When you strike them, that's a battery. Of course, you could run up behind them. They never saw you coming, and then you punch them. That would be a battery with no assault. They were never in fear of the blow because they never saw it coming. When you have both the fear and the strike, you have assault and battery. But here, California is using the term assault to indicate what I would call a battery. The shot to the face. Defendant contends that had he been present, he would have been justified in shooting Stephen since Stephen was attempting to commit burglary. By the way, this nomenclature that the court's using here is this is not black letter law, folks. This is just the observation of a lawyer who's been practicing for 32 years. Courts are sending messages when they use this type of language. And what I mean specifically is when they reference the defendant, they're not referencing him by name. They're not calling him Don. They're calling him defendant. But when they reference the burglar who was breaking into Don's home with a crowbar, which obviously would have been a deadly weapon of opportunity had the burglar unexpectedly encountered Don inside his own home, when they refer to the burglar armed with a deadly weapon, they refer to him as Stephen. Defendant and Stephen, not burglar. Defendant contends that had he been present, he would have been justified in shooting Stephen since Stephen was attempting to commit burglary. He says the defendant had a right to do indirectly what he could have done directly. That's a justification for the trap gun. And that therefore any attempt by him to commit a violent injury upon Stephen was not unlawful and hence not an assault. And the lawfulness would be that had he been present, he would have been using a deadly force to stop this felony being committed by surprise on his habitation. The state argues that the rule is unsound. The case cited by the defendant is unsound, should be distinguished here, not apply here. That as a matter of law, a trap gun constitutes excessive force, and that in any event, the circumstances were not in fact such as to warrant the use of deadly force. So again, two distinct arguments here, folks. So keep them clear. One is the argument about the trap gun. Can you use a trap gun at all, ever? Any trap readily capable of causing deadly force? That's one question. The second question is, would deadly force have been permissible even if it had been used by the defendant here, the homeowner? Two separate issues. Had the homeowner been present and had the gun in his own hand and fired it. So here we have all the historical disquisition of the spring trap. Let's see. But I'm going to skip to the second argument. Would the use of deadly force have been justified here had the homeowner been present with the gun in his own hand and fired the shot himself? After the court discusses the whole trap issue. The court continues, furthermore, even if that rule were applied here, even if we pretended that the trap was lawful, the booby trap, the defendant was not justified in shooting Stephen. Penal Code Section 197 provides homicide is justifiable when resisting any attempt to murder any person or to commit a felony or do some great bodily harm, that's Section 1, or when committed in defense of habitation against one who manifestly intends or endeavors by violence or surprise to commit a felony. Since a homicide is justifiable under the circumstances specified in 197, an attempt to commit a violent injury upon another under these circumstances is justifiable. That's the defense argument, essentially. By the terms of subdivision 1 of Section 197, that's just the self-defense argument. We're not really interested in that. Let's see. We're interested in subsection 2. And the court continues. But subdivision 2 of that section is also likewise limited. Would also they just argued subdivision 1 doesn't apply. I'm fine with that. But this is section 2 is likewise limited. The term violence or surprise in subdivision 2 is found in common law authorities. And whatever may have been the very early common law, the rule developed at common law since then that killing or use of deadly force to prevent a felony was justified only if the offense was a forcible and atrocious crime. So, folks, if you imagine historically, most felonies were crimes that inherently involved a threat of force or violence. But today we have lots of felonies that have no threat of force or violence, right? There's drug possession felonies. You write a bad check over a certain dollar amount, it's a felony. There's no threat of violence to another person in those cases. You may want to live in a world where you can kill someone for writing a bad check over a certain dollar amount. But and this is not just California. The courts throughout the U.S. have adopted the position over decades that when a statute says you can use deadly force to prevent a felony, it means, even if it doesn't say this explicitly, it means a forcible felony, even if the word forcible is not in there. So the appellate courts read the word forcible into the statute. So if the statute says you can use deadly force to prevent a felony, and you claim the underlying felony was writing a bad check, and that fits within the plain English reading of the statute, too bad for you. Because the plain English reading of the statute is not what the statute appears to say. It's what the courts say that statute says. And the courts say that felony, even though the statute doesn't include the word forcible, has to be a forcible felony before deadly defensive force is permissible. Here, the court's doing something slightly different. It's reading out the word surprise, or it's interpreting the word surprise in a way that would only apply to a forcible attack. It continues, surprise here, and here's where they're doing it, means an unexpected attack, which includes force and violence. And the word thus appears redundant. Folks, it's a fundamental rule of statutory interpretation that the presumption is that the individual words in a statute are not redundant. That each word has a specific meaning or it would not be included. And here, the California Supreme Court is just deciding on its own initiative that they don't need to follow the normal rules of statute